All right. 14A District Court for County of Washington is now back in session. The Honorable Judge Jason.
You may be seated. Court does call the case. People versus Zayn Hakaba. People versus. Well.
I'm back.
Ooh. No, anyway. Welcome back.
Thank you, Letter. Well, good afternoon. Victoria Burton here, Chief Assistant Prosecutor appearing on behalf of the people. I think I might be missing for the counsel on the other side of my matter.
Yes, Simone.
Your Honor.
He's in Zoom.
Oh, he's in Zoom. Yes, sir.
Appearing via Zoom. Thank you, Your Honor. Good afternoon. Orlando Simone, Student Legal Services. And with Zoom. Your Honor, would we be able to either pass this matter and come back to a bench conference or do one right now, briefly?
A bench conference?
Yes.
Yeah, I can do it, but then everybody else is going to have to wait, and I'm not doing that.
Understood.
I'm
willing to pass.
Let me pass it, counsel, and I'll figure something out. I'm not sure what that's going to be, but I'll figure something out.
You're right. Thank you, Your Honor. I'll be standing by.
All right. Yeah. Court calls the case People versus Cynthia Lake Pier.
Good afternoon, Your Honor. David Chan, Cynthia Lake Pier.
Ma'am, your name?
Cynthia Lake Pier.
Thank you.
Your Honor, you should have a plea form in front of you there.
I do. Plea form indicates that she's going to be pleading that there are going to be 2 counts added. Count 3 of operating while intoxicated, the 93-day offense. Count 4, resisting and obstructing attempt, the 1-year offense. On her successful plea to that, those charges, counts 1 and 2 would be dismissed. That's the court's full understanding of the agreement.
That is correct, Your Honor.
Has she signed an advice of rights form?
She did. Should be in the file. Over here.
First one.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
To
State your name.
Cynthia Lake Pier.
All right, ma'am, it is this court's understanding that you are going to be pleading guilty to 2 charges. Is that your understanding?
Yes.
The first charge is that of operating while intoxicated. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. Court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that?
Yes, sir.
All right. Count 4 is the charge of attempted resisting and obstructing an officer. That's a misdemeanor punishable by up to 1 year, $1,000 fine plus court costs. You understand that?
Yes, sir.
All right. You understand also, ma'am, that while I'm taking the plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 District Court. You understand that?
Yes, sir.
All right. Now, understanding all of that, you still wish to plead guilty?
Yes, sir.
To the charge of operating while intoxicated, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Correct.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will.
Yes. Yes,
and because you believe that you are indeed guilty of these offenses?
yes, sir.
January 18, 2025, at the location of 9876 Main Street, Whitmore Lake, Whitmore Lake, Northfield Township, Washington County, State of Michigan. Were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, sir.
What'd you have and how much?
Captain and Coke at Captain Joe's. I don't remember. Maybe.
All right. Were you stopped by the police or was there an accident?
There was a single car rollover accident, Your Honor.
Did the police arrive?
Yes,
Were you taken to the hospital?
yes,
Was there a blood draw?
yes.
And what were the results of the blood draw?
It was 0.253, Your Honor.
Ma'am, do you have any reason to dispute those blood test results?
No, sir.
All right. When the police did arrive and you were interacting with the police, what happened?
Did you attempt to kick one of the police officers?
Yes.
And at the time that you were attempting to kick the police officers, what were they trying to do?
Take me into the hospital.
They were trying to get you into the hospital, get help for you, and you tried to kick them. Is that correct?
Yes, sir.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Defense is satisfied, Your Honor. Thank you.
Court will accept the defendant's pleas of guilty to counts 3 and 4. Counts 1 and 2 are dismissed pursuant to the plea agreement. Pre-sentence investigation and report is ordered at 1483 probation. Sentencing in this matter will be
16th at 9 a.m.
June 16, 2025, 9 a.m. before Judge Fresh Hour. And we'll continue.
Marian bond.
Yes.
There is a key corrections report, maybe slightly turning. How I read it, there was a missed test in the evening and then the following morning, a late test with a very low alcohol, 0.006, I believe, which
What happened? I don't know why they didn't say this is a violation of civil progress report.
I had just received the,
Mr. Allen, on April 11th, you tested positive for alcohol.
Your Honor, this was the first time she's ever been on any type of sober link monitor. It's the first time she's ever had a criminal offense. And this was the very first day. You can see she missed the test on the night of the 10th, which is the same day she picked up the sober link. And then she missed the next morning, or tested positive the next morning in the 5 to 8 window the next morning. I believe it was just a process of her getting used to being tested.
I don't know what that means.
It means that alcohol is the undisputed heavyweight champion of the world. If she was drinking prior to that date, she had quit, and she may have still had some residue left over. She has had no positive tests since the first day of testing. And if she hasn't figured out a way to stop drinking successfully, she is going to be found out when she's either continuing on bond or when she's on probation. And we would have no objection to her continuing on the sober link as long as Judge Fresh Hour thinks necessary.
Well, except for the fact that I have an arraignment occurring in January 2025. Unless that date is wrong.
There was she was doing testing, random testing every week for 3 or 4 months, but there was no alcohol testing, regular alcohol testing. There was no sober link. There was no scram tether. There was nothing for 3 months.
Yeah, but she was under an order not to consume alcohol.
I understand, Your Honor, and I'm not saying that she did. I'm saying that it looks like this was her first time ever on a sober link, and maybe it takes her a while or took her one day to realize what the expectations were, and she cannot have any alcohol of any kind to consume anything that would possibly cause a positive reading.
She knows she's not supposed to have alcohol.
I did not. I had a root canal. I was in the process of that. Only thing I had was penicillin. Honest to God.
I have
Is
to,
that what you really want to tell me?
I'm telling you the
If
honest
you're,
to
no,
God.
ma'am, is what you want to tell me is that on April 11th, you tested positive on a sober link because of a root canal?
I had no,
I've been doing this a minute.
I had
If
no
that's what you
alcohol.
want to tell me, ma'am, I'm just asking you a straightforward question. Is that what you want to tell me?
Yes, sir.
Okay. Well, then I'm gonna let Judge Freshour handle her bond, but at this point, her bond is revoked, defendants remain.
thank you, Your Honor.
When I'm done with this document.
Can we get another
You want
date
another,
prior
you
to
want
the,
another round?
well, I want another date prior
You
to
want, you want to
June.
still mess with me?
I want her to.
What, you know, I like you.
I under, you and I are on the,
Now, no, what, go ahead, what?
you and I are on the same, you and I are on the same page.
Yes.
And actually, I asked Andrew to have her tested, deep testing. She's gonna be really mad when she hears
What
that,
is-
but I don't care.
do I have a name, Chris?
It's May 19th at 9 a.m.
May 19th.
I think that, thank you, Your Honor.
Are you done for today?
I am done for today.
Good, now I can be in it.
Thank you.
No, I'm kidding. Thank you, Mr. Chair. Court does call the case, people of the state of Michigan versus Mitchell Marian.
Ready, Your Honor.
APA Rachel McDuffie for the people.
Well,
Joe Simon on behalf of Mr. Marion. Mr.
well,
Marion.
there goes that good.
I'm here, I'm here to restore it. Restore it. Yeah.
Oh,
State your name.
Mitchell Marion.
thank you. And what are we doing?
We have a resolution, Your Honor.
Is there a plea form? I don't see. Ah, there it is. Yes, I have a plea form that indicates that the defendant. What's happening with count 2?
I'm sorry, do you want me to place it on record?
Please.
Mr. Marion is originally charged with 1 count of resisting and obstructing. Count 2, I believe, is a regular OWI. Mr. Simon requested an offer. I was able to grant that request. That offer is that he can have the attempt RNO, which is the added count 3. He would still be pleading to count 2, but there wasn't actually a way to represent that on the plea form. So that count 2 is not going anywhere with the dismissal of the original.
Is he pleading to counts 2 and 3 and
Yes.
dismissal of 1?
Yes, and count 3 will be under the prosecutor's deferred sentence program.
That's what I have. Okay, so I just need. He pleading guilty?
He is. And just to be unequivocal, the deferred is only to count 3.
I mean, you need to sign it.
Oh,
Raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
State your name, please.
Mitchell William Marion.
Sir, it is this court's understanding you're going to plead guilty to 2 misdemeanor charges. Is that correct?
Yes, Your Honor.
First is a stated count 2 of operating while intoxicated. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Court could order community service or any rehabilitative programs the court deems necessary. The court could also order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, Your Honor.
All right. And also that you'll be pleading to an added count 3 of attempted resisting and obstructing an officer.
Yes, Your Honor.
That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. Do you understand all of that?
Yes, Your Honor.
All right. So you also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 1484 District Court.
Yes, Your Honor.
All right. Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
To the charge of operating while intoxicated, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, sir.
and of your own free will,
Yes, Your Honor.
and because you believe that you're indeed guilty of these offenses?
Yes, Your Honor.
February 23rd, 2025, at Marian Road near Michigan Avenue in Saline Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, Your Honor.
What'd you have and how much?
I had liquor and I believed it was only 3 or 4, but it was probably more than that.
Were you stopped by the police or was there an accident?
I was stopped
What were you stopped for?
speeding.
All right. You're not disputing the right of the police to stop you in this case, are you?
No, Your Honor.
Were you ultimately arrested?
Yes,
Were you taken to the hospital or to the police station or both?
both, Your Honor.
Okay. At the hospital, was there a blood draw?
Yes, Your Honor.
And what were the results of that blood draw?
.166.
Do you have any reason to dispute those blood test results?
No, Your Honor.
When you came into contact with the officers, what happened?
I pulled away from the officer and I did not obey his command.
He was trying to arrest you at that point,
Yes.
and it was a Michigan State Trooper that you did that to?
Yes, Your Honor.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
The people are satisfied.
Yes, Your Honor.
Court will accept the defendant's pleas of guilty to counts 2 and 3. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be June 10th, 2025. I'm sorry, 10. 9 a.m. before Judge Freshour. Bond continue.
Thank you, Your Honor.
Thank you, sir.
Outside.
Court calls the case of the people versus Matthew. Is that it for you, Mr. Stone?
Your Honor, I told you I was here to restore your good mood. There's only one today.
Oh, I am happy.
Next week may not be.
Yeah, I hear you.
Jeremy Glick on behalf of Mr. Matthew Newton. Can you state your name for the record?
Yep, Matthew Newton. Thank you. All right, you're requesting an adjournment.
Yes, Your Honor.
How long did you need?
After May 16th, Your Honor, he has an assessment scheduled with Mr. Statman on May 16th.
16th?
Yeah.
That objection, probable cause will be May 22nd.
Thank you, Your Honor.
Thank you, Your Honor.
25, 9 a.m. Or as your invite indicates. Okay?
Thank you, Your
Bond
Honor.
continue. Thank you, sir.
Have a good day.
Court calls the case of the people versus Michelle Lavas.
Hold on, Your Honor.
Wow, 2 days in a row.
Sorry?
2 days.
2 days in a row.
Don't see you forever, and then 2 days in a row.
Yes. I'm sorry. Thank you.
John Shea, Your Honor, with and on behalf of Ms. Lobaz.
And you're requesting an adjournment.
We are, Your Honor. This is the first PCC. It's a pretty intensive discovery case, and we're still going through the stuff.
Gotcha. Will the 22nd work for you?
Yes.
Probable cause conference will be adjourned May 22nd, 2025, 9 a.m.
Thank you, Judge.
Bond continues.
Thank you.
Court calls the case people versus Mark White.
David Knock on behalf of the defendant who is present, Your Honor.
Your name?
Your Honor.
Thank you. Mr. Knock, long time no see. How are you doing?
Peachy Keen, how are you, Your Honor?
I'm wonderful as always.
Your Honor, the prosecutor and I were having a brief chat about a modification of the bond conditions. We expect to submit a stipulated order. One of the witnesses who my client's bond precludes him from visiting, he has a business with her. She's not a victim in the case. And so it's a landscaping business. They want to start making money for this summer. Prosecutor doesn't object. And so I'm just giving you a heads up that I expect the prosecutor and I to agree on an order about the bond modification conditions. I also expect to file a motion for bond modification where I don't expect the people to agree about removal of the tether, but we'll submit something in writing before the next time we're in front of the court. And maybe I'll be maybe I'll be wrong on that.
I would be objecting to a change in the tether, that's correct. And we did have discussions about some kind of modification of the bond's contact with Aaron Avery. I will say that we did discuss some kind of order. Ms. Avery is represented by Mr. Simon as well. I would be okay with some kind of limited contact as far as the equipment they share goes, but we'll see, I guess, if we can come to an agreement on the wording of that order.
Okay. The people got us some supplemental discovery as they promised, but they got it to us, I don't know, 2 weeks ago or something. We're making our way through it. And I asked if the case is still under investigation. They said it is. So I expect they'll get us some more discovery. So we're asking for an adjournment of the PCC.
How much time did you need? And you didn't fill out a green sheet, did you, Mr. Knock?
I would say a couple of weeks, Your Honor.
Probable cause conference will be adjourned May 15th, 2025. 9 a.m. bond continued.
Thank you, Your Honor.
Thank you. I'll sign off on that. Thank you.
Thank you, Your Honor.
Court calls the case People versus Marissa Bridgman.
Sherilyn Foster Tucker on behalf of Marissa Bridgman, who is appearing via Zoom.
All right. Ms. Bridgman, state your name, please.
Marissa Bridgman.
Counsel, you're requesting an adjournment.
That is correct, Your Honor.
Probable cause conference without objection, May 15th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you. Have a good day.
Mr. Vincent, go ahead, sir.
Good afternoon, Your Honor. Michael Vincent on behalf of Flores Nava. Put your name on the record, please.
Andres Flores Nava. Take your hands out of your pockets.
Yeah.
All right. What are we doing?
Need a prelim exam date, Your Honor?
Discovery is complete.
Yes, Your Honor.
People have their witnesses available to 6.
We'll do our best, Your Honor.
Will that date work for Mr. Vincent?
Yes, Your Honor.
Thank you. Preliminary examination in person, February 6, 2025.
9 a.m. before Judge Perry.
9 a.m. before Judge Perry. Bond will continue. Thank you. Court calls the case of the People versus Satie Padro.
Alexander on behalf of the people, Your Honor.
Excuse me, I'm on the wrong side. Michael Vincent on behalf of Satie Padro.
Satie Padro.
Say your name.
Satie Padro.
Padro.
And again, we need a prelim exam date, and I like to adjust bond at the full time.
And all discovery is,
Yes.
people have their witnesses available to 6.
We'll do our best, Your Honor.
Preliminary examination in person, February 6, 2025. That's going to be Dan.
Yes.
At 12 noon. That's before me. As to bond.
Yes, right now, Ms. Fodderell is not allowed, oops, excuse me. Thank you. Go to her home on 590 to 590.
Yeah.
590 Bagley as a result of these charges. However, we have been informed, her father and stepfather, Chris Fry, who is here, was informed that the accuser in this matter has moved out of the house. The house is empty. Ms. Fodderell has a 4-year-old and a 2-year-old who would love to go back home. Mr. Fry is here to testify under oath regarding a text message
But the individual that would be testifying is not the individual who resides in the premises. Or
He
it's not the
had, he
victim.
had been living there. He has now moved out. The house is empty.
And Your Honor, we have not received any confirmation from him or anyone that he has moved out as of today.
I have a witness I can bring forth to testify, Your Honor.
Well, but this witness, what's the relationship of this witness?
It's stepdad to my client who got a text message from the gentleman who's accusing my client of domestic violence and what all.
Yeah, I can't do anything with that. Has the people heard from the alleged victim in this case at all?
We have before, I don't know if we've heard from him before this hearing today, but we did before the last PCC hearing. We haven't had any confirmation that he is not at that address anymore. So I don't know.
Well, until we get that confirmation, Mr. Vincent, I'm sure you can understand. I mean, I get the position that your client's in, but I'm not going to change that condition.
I'm reluctant to contact this gentleman. I don't like doing.
I know, and that's fine, because what's really going to happen is they're going to need to communicate to the victim's advocate or the prosecutor that they're no longer at that address. That's typically the only way
Yes.
that I'm taking it.
I would appreciate it if they would proactive contact the
I
gentleman.
think Ms. Zenda is probably all over it already, even before you got all those words out.
It's pretty fast.
Yeah.
Well,
Okay.
All right.
So at this point, Bond will continue with its conditions.
Thank you.
All right, thank you. Court calls the case, People versus Zayn Hakaba.
That's the one for the people.
Good morning, or afternoon, sorry. Sometime. Charles Noe appearing on behalf of and with Mr. Huckabee.
All right, I have a plea form.
That's correct, Your Honor. The defendant is going to be pleading guilty to an added count 4 of operating while intoxicated, second offense, 1-year misdemeanor with mandatory minimum 5 days in jail, as well as currently charged count 3, open container in a motor vehicle. In exchange for pleas to those counts, count 1, operating while intoxicated, third offense, and count 2, driving out of suspended license, will be dismissed. This plea is made with the understanding that the defendant has been screened and accepted for the Lenawee County Sobriety Court already, and he'll be entering into that at some point. I did discuss with the defense counsel that generally what we do in Washington County is allow someone to be sentenced by their respective district court, in this case, judge, not sure which judge, will be 15, and then he'll go from there into Lenawee County Sobriety Court. There are no other agreements.
Is that a correct statement, counsel?
It certainly is.
All right. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Zayn Hakaba.
All right. Sir, it is this court's understanding that you're going to plead guilty to 2 misdemeanor charges. Is that your understanding?
Yes.
The first is the charge, the stated count 3 of open intoxicant a motor vehicle. That's a misdemeanor punishable by up to 90 days, $100 fine plus court costs, community service, and substance abuse screening. You understand that, sir?
Yes.
Okay. The other charge is the charge added count 4 of operating while intoxicated, second offense. That's a misdemeanor punishable by up to 1 year incarceration, a mandatory minimum of 5 days in jail. Court could also order, could also order court costs, could order you to pay the cost, could order community services as well as any rehabilitative services. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Moore in the 15th District Court.
Yes.
All right. Now, understanding all of that, do you still wish to plead guilty?
Yes.
To the charge of open intoxicant a motor vehicle, how do you plead?
Guilty.
To the charge of operating while intoxicated, second offense, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form. Yes. You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of these offenses?
Yes.
I know. On the date of November 3rd, 2024, location of North University near Fletcher Street in the city of Ann Arbor, Washtenaw County, state of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
Do you know what you had and how much?
Vodka and 4 or 5 shots.
All right. Were you stopped by the police or was there an accident?
I was stopped.
Well, why'd the police stop you?
Driving without headlights.
All right. Are you disputing the right of the police to stop you in this instance?
No.
All right. Were you ultimately arrested?
Yes.
Were you taken to the hospital
Yes.
for a blood draw?
Yes.
What were the results of that blood draw?
0.228.
0.228?
Yes.
Do you have any reason to dispute or contest those blood test results?
No.
Had you previously been convicted of operating while impaired on October 15, 2019 in the 79th District Court and or operating while intoxicated on or about December 17, 2021 in the 2A District Court?
Yes.
On that date, when you were stopped, was there open intoxicants in the motor vehicle?
The prior, not this case around the prior one, you mean?
No, I'm talking about this case. Was there?
Yes, there was.
Was there alcohol in the vehicle? What was it?
Vodka.
Vodka? What was it in a container?
Yes.
It was in the bottle?
Yes.
Was the seal broken?
Yes.
Did you know that it was broken?
Yes.
Was it yours?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's pleas?
Two people are satisfied.
The court certainly has, and it would be proper.
All right, court will accept the defendant's plea to guilty to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
April 25th tomorrow at 9 a.m. It's the only day that I have.
tomorrow.
Yeah.
That's the quickest I've ever seen.
How did,
That's the date they gave me.
for this week?
Yes. Can I double check what we went over? And it was for 25th.
I think that Judge Moore generally has dockets on Friday mornings for these types of cases.
Okay, but there's a lot of those coming up. And I know she's listening. Here she comes.
Would you like me to contact them?
Yes, thank you. Have a seat. We'll get you a new date.
Okay, thank
All right,
you.
that actually will. All right.
Do we have to go back on the record? Can I just get that from the clerk?
Bond will continue. We'll get you a new date.
Okay.
And you don't have to come back.
Thank you, Judge. In bond, we did present the court with a bond stipulation to amend bond.
Yes. And
So my client can go to South Korea for work.
We discussed it at the last hearing, Your Honor. People had no objection as long as the defendant remains testing and compliant with his testing.
Yep, that's why I put the clause in there, all the terms remain in full force and effect.
Okay, that'll work.
Okay.
We're good.
So no sentencing tomorrow, right?
We're gonna call.
Okay.
Yeah.
All right, we'll figure it out.
And we'll just pick a Friday.
Yeah, we'll figure it out.
Right, we'll figure it out. All right,
Okay.
but you can get that from my staff.
That's what I'll do. All right. All right. Thank you. Thank you, Your Honor. Nothing further.
Court calls the case, People versus Michael McClure.
And good afternoon, Your Honor. Joseph Hall appearing for and on behalf of Mr. McClure, who appears by Zoom without objection. Mr. McClure, if you could please state your name for the record.
Michael Thomas McClure.
Thank you.
All right, what are we doing?
Your Honor, at this time, I've discussed the options with my client, and after being fully advised, he desires to waive his right to a probable cause conference and proceed to the circuit court.
Into a preliminary examination?
Yeah, yes, Judge. Thank goodness you're here.
I know, I speak Joe Hall, so I know what that meant. All right, sir. Sir, you're waiving your right to a preliminary examination?
Yes, sir, Your Honor.
All right, you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense is alleged or the offense alleged was committed and that you committed it.
Yes, sir, Your Honor.
And you understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir, Your Honor.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Mr. Hall.
Your Honor, at this time, my client would waive formal reading and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be set for
June 25th at 1:30 before Judge Conlon.
June 25th, 2025, 1:30 before Judge Conlon.
Thank you very much, Your Honor.
Thank you. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you. Thank you, Mr. McClure.
Thank you.
Court calls the case, People versus Matthew McGill.
Jacob Kennedy, Your Honor.
Jim.
Good afternoon, Your Honor. My name is Randall Lewis, and I am standing in for Miss Parisa Cedrina. And that is with Mr. McGill's consent, and he consents to have this hearing by Zoom. Is that correct, sir?
Yes, sir.
Okay, and state your full name for the record, please.
Matthew McGill.
Thank you, Your Honor. We're here for two. We have to address two issues. The first is the competency report dated March 21st, 2025 by Dr. Margot Gilbert at the Forensic Center. I believe that both parties are stipulating to that report at this time and await the court's finding on the issue of competency, which is authored at the end of the report.
And they are indicating that he is competent to stand trial at this time. Is there any additional evidence from the people?
No, Your Honor.
All right, the court, after review of that report, would find that the defendant is competent to stand trial. Specifically, the court would find that the defendant can understand the nature and object of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent.
Yes.
And counsel, what you will need to supply to the court an order on competency.
We will, Your Honor. Thank you. As to the preliminary hearing, Your Honor, at this time, we've executed a waiver, and that was sent to the court this morning by Ms. Cedrina. And my client waives his right to have a preliminary hearing in this case with an understanding that the matter is going to be bound over to circuit court for further disposition.
Is that correct, sir?
Yes, sir. That is
all right.
correct.
And you understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
And you understand you'll not have that hearing. You'll proceed to circuit court for final resolution of this matter. You understand that?
Yes, sir, I do.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts.
As to arraignment, Your Honor, my client stands mute and waives a formal reading of the charges.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to both counts. Pretrial in this matter will be set for
June 25th at 1:30 before Judge Conlon.
June 25th, 2025, 1:30, Judge Conlon.
Your Honor, thank you very much.
Thank you. Bond will continue. Have a great day, guys.
You as well.
That's it for me today. Appreciate it. All right. Court calls the case of People versus Spencer Norton.
Good afternoon, Judge. Jeff Perlman on behalf of Spencer Norton.
Mr. Norton.
I believe my client was on Zoom.
I don't. You haven't? Spencer Norton. I do not have him, counsel.
Judge, would it be possible to waive his presence? We're requesting an adjournment of the PCC.
I don't waive the presence unless the people agree, and I don't think they are given this.
I would ask to approach, Your Honor, but I can't do so in this format. I'm actually not going to agree to waive his presence. I believe, was he authorized up here on Zoom as well today?
I don't know. I'm assuming he was he?
so.
Yes, so I'm not, for that reason, he had easy access to court today, so I wouldn't be waiving his presence. We were planning to adjourn, but I'll leave that up to the court.
Judge, if the court's not in agreement, I just ask to pass the matter briefly so I can get him on.
I'm running out of time in this block. I got a big hearing in front of me, but I'll pass it. But you got about 4 cases to find your client.
Thank you.
Court calls the case, People versus Kennedy Braddock.
Richard McDuffie for the people.
David I. Goldstein appearing on behalf of the defendant.
Kennedy Braddock.
Thank you.
Any Friday.
May 28th, Your Honor?
Told you, I should have just picked one.
May 28th, that was the date yesterday.
Yeah, exactly. It was Emily's choice, that's what it would have been. All right. Okay, what are we doing in this case?
Your Honor, I was going to ask the court to set a preliminary examination, but that's going to depend on an answer from a question I have to ask Ms. McDuffie, okay?
Oh, boy.
Okay, when we were here last week, I asked for videos, and I did get some videos. What I got were body cams. My question to her, and you may not know, is are there any store videos?
Well, Mr. Goldstein, I'm not sure because you actually had Ms. Douglas last week. I had a potential.
So you're right. I'm sorry.
I had a potential offer for you. Why don't you go ahead and turn that green sheet in and we can go from there.
Okay.
Okay.
All right, Your Honor, I'd like her to check and see if there's going to be any,
So we're adjourning.
Yeah.
All right, how long is it gonna take you to chat?
2 minutes, Your Honor.
You want the 15th or the 6th?
15th, please.
Cause conference adjourned, May 15th, 2025, 9 a.m. or as your invite indicates, bond will continue. Thank you, ma'am.
Thank you.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Antoine Pitts.
David I. Goldstein appearing on behalf of the defendant.
Mr. Pitts, come on. It's your case. State your name.
Antoine Pitts.
Thank you.
Your Honor, I've requested an adjournment in this matter, and I'll let the court know why. Again, there were videos that I requested. I did get them. However, they're coming on a new platform directly from the Michigan State Police, and we're having a lot of trouble getting them to download and open. So I'm still working on that. So if you were to ask me, do I have all the discovery, I'd have to say no.
No. Got it. Okay. Probable cause conference, May 15th,
Please, Your Honor.
2025, 9 a.m. or as your invite indicates, bond will continue. Thank you.
Your Honor, there is one quick matter on this bond. When bond was set in this matter, he was ordered to test at community corrections. He was already testing for probation. And he's asked me to ask. He's on probation to Washtenaw County Circuit Court, Your Honor.
And my job is like on me about it.
So he's basically testing twice.
How often are they testing?
Once a month.
Once a month?
Yeah.
There's testing here, the frequency is 1 time per week.
Yeah. I don't want to get fired though, Mr. Simpson.
Pardon?
I don't want to get fired though. I got to keep calling off my job. Oh, I got to have a job.
This is a drug possession offense, Your Honor, with the relatively recent of offense. And so, Your Honor, we do believe that the more frequent testing is appropriate at this time.
What was the alleged drug of choice for him?
Cocaine.
Got it. And you're working?
Yes.
What I'll do is I'll send over an order. I'm gonna reduce this testing. Young man, if you mess this up,
I'm not.
I know, people tell me that all the time. So just listen to me. You mess it up, Mr. Goldstein will tell you, I'm not gonna be listening to a lot. You will go. You hear me?
I understand.
So I'll reduce this testing to once every 2 weeks. So I'll cut it in half.
All right, thank you.
Thank you, Your Honor.
All right, that way at least he'll have 3 tests. He'll have 3 tested a month.
That's right.
Get 1 down there.
Instead of 5, and that's
Right.
That's great. Thank you, Your Honor.
Court does call the case People versus Ashkan Khan.
Ready, Your Honor.
Rachel McDuffie for the people.
Good afternoon, Your Honor. For the record, Tim Davalski on behalf of defendant Khan.
Okay, I have before me a plea sheet that indicates that the defendant is going to be pleading guilty to counts 3 and 4, added counts 3 and 4, which is use of a narcotic, 1 year fine for cost offense, and open intoxicants in a motor vehicle, which is a 90-day, $100 fine for court costs.
That is correct, Your Honor.
All right, upon the successful plea to that charge, counts 1 and 2 would be dismissed. There is also an agreement of no objection to 7411 in this case.
That is correct.
Okay, I have him sworn.
Raise your right hand. You solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name.
Ashkan Khan.
All right, sir, it is this court's understanding you're going to plead guilty to 2 misdemeanors. Is that your understanding?
Yes, Your Honor.
The first is an added count 3 of use of a controlled substance. That's a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that?
Yes, Your Honor.
And also the charge of open intoxicants in a motor vehicle, a misdemeanor punishable by up to 90 days, $100 fine plus court costs. You understand that?
Yes, Your Honor.
Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
To the charge of use of a controlled substance, how do you plead?
Guilty.
To the charge of open intoxicants in a motor vehicle, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Correct, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerced you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will,
Yes, Your Honor.
and because you believe that you're guilty of these offenses?
Yes, Your Honor.
November 9, 2024, at the location of Carpenter Road near Packard Road, Pittsfield Township, Washtenaw County, State of Michigan. Were you in a vehicle at some point?
Yes, Your Honor.
And was there alcohol or some type of liquor in that vehicle?
Just empty bottle with the.
What was it?
Yes, Your Honor.
What did you have? What kind of alcohol was it?
It was just whiskey.
Whiskey? And the seal, there was at least some liquid in that bottle.
Correct.
And the seal was broken on that bottle? All right. And on that same date, you were using a substance, a controlled substance, hydrocodone?
Yes, Your Honor.
Did you have a prescription for it?
No.
All right. And you knew you had it in your possession?
I didn't know I had it. Yes, I did.
All right. And you had used it recently or that day?
Yes, Your Honor.
All right. Counsel, have I complied with the court rule?
You have, Your Honor.
Accept this defendant's pleas.
People satisfied.
Court will accept the defendant's pleas of guilty to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be May 14th, 2025, 9 a.m. That's before me.
Thank you, Your Honor.
Thank you, Bond.
I asked.
Will continue. On the left-hand side down the hallway, when you're walking out, you can stop at our probation department and begin the process so that we will have a smooth sailing come the 14th. Okay? Thank you. Court recalls the case People versus Spencer Norton.
APA Rachel McDuffie for the people.
Good afternoon again, Judge Jeff Perlman on behalf of Spencer Norton. Judge, I've called him several times, continues to go to voicemail. I'm not sure what's going on. He knew about today's court date. Again, I would request for a brief adjournment. He hasn't, since I've been representing him, he hasn't missed any court dates. And I'm hoping there's a valid explanation.
Well, there's a process for setting aside if there's a valid reason which you can get to the court, but at this point, I'm going to issue a bench warrant for his failure to appear. Bond is set in the amount of 10,000 cash surety. That warrant will issue immediately.
Thank you, Judge.
Thank you. Is, oh, there's Ms. Burton Harris. Tell and put Mr. Simone into a breakout. All right, I'm gonna leave.